Good morning, everyone. My name is Mike Delaney, and I'm pleased to welcome you to our update for recruitment businesses. And we've got an interesting agenda today. Jess, next slide, please. We'll be covering use of agency workers during strike action, which is quite topical in view of the government announcements that many of you will have heard this morning. Particularly, there were debates on Radio 4. We'll also be looking at the EU Repeal Revocation Act, which could cause some uncertainty. And I'll be looking at that piece of legislation in relation to use of agency workers. Again, it's topical in the fact that the House of Commons Library published an up-to-date report only yesterday. Lorna will be looking at a redundancy update, and whilst the recruitment sector generally is fairly buoyant, there are certain sectors where recruitment is not so buoyant, particularly in hospitality, and certain businesses are struggling and may need to reorganise, restructure, and unfortunately make redundancies. And Lorna will take you through some recent updates on that. And finally, I'll be looking at the resurrection of the non-compete clauses in unrestricted covenants contained in contracts of employment, which again seem to be enjoying a renaissance. And finally, Lorna will look at some programs that we have on our VWV Plus platform. Next slide, please. I want to start off by looking at the use of agency workers to fill in for striking workers. And many of you will have heard this morning government proposals to introduce minimum service levels of activity and operation during strikes, particularly in public sectors, including healthcare, transport, and education. But also as well, some of you may be aware that in July last year, the Conduct of Employment Agency and Employment Business Regulations, which essentially govern the way in which temp agencies, as I call them, supply temp agencies. And also what's happened there is that with effect from that date, employment businesses can supply agency workers to hirers who are involved in strikes. Now, that piece of legislation is the subject to a judicial review, which is launched by Unison in September and more latterly the TUC, and also as well a number of other trade unions have also piggybacked onto those applications. Now, the unions have essentially managed to persuade a judge at first instance that there is a reasonable case to go before High Court judge by way of a full hearing, and there is set to be a full hearing in March. The trade unions see the legislation as being impinging the individual right of individuals to strike. It's referred to as anti-worker, anti-striking legislation, and indeed the REC, the Recruitment and Employment Confederation, which is one of the voices for the recruitment sector, have called the proposals unworkable. The basis of the challenges are that the government failed to consult with the trade unions, as is obliged to do under the Employment Agency Act 1973, and also the legislation undermines the right of individuals to strike. And as I was saying, there is a full hearing expected in March of this year. But I guess at this time, I suppose for agencies, what you need to be considering, does the legislation provide agencies, temp agencies, an opportunity to supply temps into sectors which are experiencing strikes? Or indeed, is it unrealistic to expect temps to cross picket lines? Maybe that's something that you're thinking about when you are talking to your agency workers. And also as well, is there anything to stop someone on strike supplying services as a temp? So in other words, I've heard of situations whereby nurses, for example, or health workers go on strike and then enroll with an agency and are supplied via an agency to a different NHS trust. Morally, that might be wrong, but is that happening? So it's something you may want to consider. Next slide, please. I also briefly want to draw your attention to the retained EU law revocation and reform bill, which is currently going through the Houses of Parliament. The bill was introduced on the 22nd of September 2022 and arises as a result of the decision to leave the EU. And the aims of the bill are to remove EU law with effect from 31st of December 2023 from the UK law statute book. And so what the bill seeks to do is to revoke various subordinate legislation, downgrade the status of principal various EU directives, and indeed case law. Next slide, please. It would also as well remove from the UK law the general principles of EU law. So essentially this could cause a lot of uncertainty in the law. And what I've referred to on the slide here is the impact that the legislation would have, for example, on agency workers. Agency worker rights derive from the EU directive. If the EU directive no longer has a place under UK law, then I guess what is the status of agency workers? Would there be new legislation to effectively put in place alternative legislation to replace the agency worker regulations? We don't know. One of the difficulties is that the bill, as it currently stands, seeks to be operational with effect from the 1st of January 2024. And in the committee stage, which occurred, and there were various sessions between the 8th and 29th of November, the opposition sought to extend the impact of the legislation until the end of 2026. And that was actually defeated because of the fact that the government has a majority in the House of Commons. So all I would say is that you need to keep an eye on this legislation. No date has yet been set for the third reading, but generally speaking, if the bill becomes law, which I suspect it will do at some stage, then there will be a lot of uncertainty created as a result of the bill if it goes through in its current form. Next slide.
Thanks, Michael. So now I'm going to take you through a brief update on the law around redundancy. There's a few cases we're going to look at which have come out recently, and there is some forthcoming legislation on the cards as well. So we'll start with a little reminder about what is redundancy. Jess, if we could just have the next slide, please. Thank you. So what is redundancy? Well, essentially, redundancy is one of the 5 potentially fair reasons for dismissing an employee, with the others being capability, conduct, illegality, and some other substantial reason. Now, it has a statutory definition, which is set out in the Employment Rights Act, which is summarised here on the slide for you. So there are essentially 3 types of potential redundancy situation. One is where there is an entire business closing and therefore the employee is no longer required. One is where a business is intending to cease carrying out work at a particular workplace, and the workplace is closing, and that again gives rise to a potential redundancy situation, although sometimes a redundancy situation in that circumstance can be avoided if an employee has a mobility clause which you can exercise and choose to move them elsewhere to work. And the last, and perhaps probably the most common type of redundancy situation, is where there is a reduced requirement for employees to carry out work of a particular kind at the place at which they're employed. So that reduced requirement for employees. And that's the situation that gives rise to the most sort of dispute and case law. And of course, the crucial difference between a redundancy dismissal and any of the other dismissals, the capabilities, the conducts, etc., is that where the statutory definition of redundancy is met, an employee is also entitled to a statutory redundancy payment if they've got 2 years service. So if I could move on to the next slide, please. So as I said, redundancy is one of the potentially fair reasons for dismissal, but in order to actually dismiss fairly for redundancy, you not only need a fair reason, but you also need to have gone through a fair process. So the leading case in this is the House of Lords case called Polk. It's a very old case. And in that case, the House of Lords said that in the case of redundancy, an employer will not normally act reasonably unless it warns and consults any employees affected or their representatives, adopts a fair basis on which to select for redundancy, and takes such steps as may be reasonable to avoid or minimise redundancy by redeployment within its own organisation. So we've broken that down. The key steps that you need to follow in any redundancy situation are: there needs to be adequate warning and consultation, and where there's 20 or more employees at risk, that will involve consultation through representatives. If there's less than 20, that's normally done on the basis of individual consultation. There needs to be a fair basis for selection, so that involves identifying fair and reasonable selection pools and as to who will be at risk of redundancy, and then applying within those pools fair, objective and reasonable selection criteria. And it also involves the consideration of suitable alternative employment. So the thing to remember is you're probably familiar with what we call the range of reasonable responses test, which normally applies in sort of conduct or capability dismissals. And what the tribunal do is they recognise that when an employer is dismissing an employee, there will be a range of reasonable responses open to that employer, and as long as an employer takes one of the responses that is within that range of reasonable responses, then it's not for a tribunal to substitute its decision. It should find that a dismissal within the range of reasonable responses is fair. Now, in a redundancy situation, as you can see, there will be a number of decisions that an employer has to take leading up to the redundancy dismissal. So it will have to take a decision about why it's what's given rise to the redundancy situation. It'll have to take decisions about what pool is appropriate, what criteria it's going to apply before taking its final decision. And that range of reasonable responses test essentially applies to all the decisions that an employer takes as it goes through that redundancy process. So as long as the tribunal is satisfied that the decisions taken at each stage are within that range of reasonable responses, then a tribunal should find that the dismissal is ultimately fair by reason of redundancy. And if we move on to the next slide, as I've mentioned, one of the key things that the employer will need to decide, therefore, is around selection pools and selection criteria. And we're going to look at a couple of cases in a moment in which it's been the sort of decision around selection pools, criteria in interplay with consultation that have given rise to the challenge. So just as a reminder, as it says there, fair selection involves the application of fair and objective selection criteria to a pool. Now, as I've mentioned, the employer has generally got wide discretion over the pool. The tribunal recognises that there is a range of reasonable responses, and as long as the employer has applied its mind and chosen a reasonable pool for selection, that should be normally fine. In general, an employer is likely to want to try and narrow a pool as much as possible to avoid disruption to staff, to minimise the number of staff that it's putting at risk. But employees, generally speaking, are likely to try and argue for wider pools, because the wider the pool, the lower their chance of being selected out of that pool is. And therefore, sometimes we find our situation ourselves in a situation where an employer is arguing for a pool of one, and that's what these next two cases that we're going to look at involve. So if I could have the next slide, please, Jess. Thank you. So the first case we're going to look at is the case of Morgaine and Bradford Teaching Hospital, which was an EA decision just in November last year. And it involved Miss Morgaine, who was a nurse employed at Bradford Teaching Hospital, and she was employed on a series of fixed-term contracts. And there was another nurse who carried out a very similar role to her, who was also employed on a series of fixed-term contracts. Now, the trust was facing some financial difficulties, and it decided it needed to make one of the nurses redundant, one of the two nurses employed in fixed-term contracts redundant, and it decided that it was going to select Miss Morgaine purely on the basis that her fixed-term contract was due to expire first before the other nurses. So at that point, the trust informed Miss Morgaine that she was at risk of redundancy and told her that they would consult with her, but essentially the consultation only involved a search for alternative employment, because by the time it had told her that she was at risk of redundancy, she was the only person that had gone into the consultation process. No alternative employment was found, and she was dismissed by reason of redundancy, and she brought a claim for unfair dismissal. The claim was dismissed at the first instance by the Employment Tribunal, but she appealed on to the Employment Appeal Tribunal, and the Employment Appeal Tribunal allowed the appeal. They found that there hadn't been proper consultation, and therefore that Miss Morgaine had been unfairly dismissed. What the EAT said was that in order for the consultation to be genuine and meaningful, it must take place at a stage where the employee can still potentially influence the outcome of that consultation process. Now, in this case, because the employer had effectively chosen the selection criteria that it was going to adopt, which was the sole criteria of when their fixed-term contract expired, and had already applied that criteria before it informed the employee that she was at risk, that had the practical impact of determining who would be put at risk, who would be made redundant, and the whole thing was effectively a fait accompli before consultation even started. And the EAT as well, they said this was not within the band of reasonable responses in the absence of consultation to adopt one criterion which simultaneously decides the pool and which employee is to be dismissed. So I think this case is quite a useful reminder that a pool of one, where actually there shouldn't have been a pool of one, where it's only a pool of one because the employee has already determined and applied its selection criteria, will not be reasonable. So that's not to say that if you've got an employee in a unique role, that can legitimately form a pool of one, which you can then go on to consult with. But if there are other employees in similar roles, then really consultation should start at the point at which you are determining what the selection criteria will be. And you should consult with all the affected employees at that point. And I think it's also quite a useful reminder, something that I think employers do sometimes forget, that the expiry of a fixed term contract and the non-renewal of that fixed term contract can amount to a redundancy situation in law. So even if there is just one employee employed on a fixed term contract, if that fixed term contract or a series of fixed term contracts have gone beyond 2 years and the employer is considering not renewing it, it does need to consider what the reason for that non-renewal is, because it could give rise to a redundancy situation and create an entitlement to a redundancy payment. And the next case we're looking at, if I can move on to the next slide, is also a case that looked at sort of the issue, it's very similar, the issue of a pool of one, and it's the case of Texera and Zika Restaurant Limited, which again was a very recent EAT decision just in December of last year. And in this case, Mr. Texera was employed as a tandoor chef in a restaurant, and at the time of his dismissal, he was one of a team of 10 chefs employed at the restaurant. However, he was the only non-speciality chef And the tribunal found that although he helped in various different departments, he wasn't able to effectively run any of those departments. And he also had far shorter service than all the other chefs and was more junior than all the other chefs. But as a result of the pandemic, there had been a reduction of work in the restaurant, and the restaurant had determined that it needed to make one of the chefs redundant. And it basically called Mr. Texera to a meeting without warning, without consultation, and informed him that he was the chef that was going to be made redundant. So he brought a complaint of unfair dismissal, and the employment tribunal agreed that his dismissal was procedurally unfair because there had been no warning, there had been no consultation. However, it also concluded that on the particular facts of this case, had warning and consultation been carried out, it would have inevitably led to the decision that Mr. Texera would have been the one selected for redundancy and dismissed in any event, and it therefore reduced his compensation by 100% to nil. Now, Mr. Texera appealed that decision to the EAT, and the EAT upheld the appeal. So it found that having a pool of one, even where there is a pool of one, doesn't always mean that a dismissal is necessarily going to take place when it did, because even where a dismissal might seem inevitable, the process of consultation is likely to delay the dismissal by a week or two, and therefore would have entitled the employee to some more pay, and therefore to reduce the compensation by 100% was wrong. And it also criticised the tribunal's finding that going through a warning and consultation process would have made no difference to the dismissal, because it said even where there is a small pool, there is still a duty on an employer to carry out a fair redundancy process, and doing so could have resulted in there being a larger pool or some different selection criteria, and there was always a chance that it could have led to a different outcome. So again, just I think a very clear reminder in these two cases that employers should always ensure that they carry out a full and fair redundancy process, even when it seems inevitable to the employer that by the time a pool has been identified and selection criteria have been applied, that it's going to be a particular employee, that actually in reality you do need to alert all the employees who could potentially be at risk, start a consultation process, consider carefully with them the selection pool, the selection criteria, and then only make a decision once that consultation process has carried on. And then you can carry on, notify the remaining employees that are no longer at risk, and then carry on with your consultation with the remaining at-risk employee, looking at things like alternative employment before finalising your decision. So then if I can move on to the next slide, please. And the next slide is a case around disability discrimination in a redundancy context, and in particular the duty to make reasonable adjustments. So as you'll be aware, an employee is disabled for the purposes of the Equality Act if they have a physical or mental impairment that has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. Where an employee meets that definition, then an employer is under a positive duty to make reasonable adjustments to any physical features or provisions, criteria or practices that create put that disabled employee at a disadvantage as compared with the non-disabled employee. Now, in the context of redundancy, we do frequently see reasonable adjustments being made, often to selection criteria, because a very, very common selection criteria in the redundancy context is to use absence as one of the scoring mechanisms. And what employers should think about doing in that situation is actually discounting disability related absence from the absence records to ensure that disabled employees are not disadvantaged by higher levels of absence caused by their disability. So that's quite a common one, but in this particular case, it was another adjustment that Mr. Hilaire was asking for. So specifically, Mr. Hilaire was employed by Luton Borough Council. Now, it was going through a restructuring process, and part of that restructuring exercise, it put a number of employees at risk and asked them to apply for new roles that had been created as part of the restructure. Now, Mr. Hilaire was disabled for the purposes of the Equality Act because he suffered with depression and also with arthritis. He said to his employer that he was too unwell to attend an interview for a new role, and he provided a fit note to say that he was sick. So the council, who had already interviewed 13 other employees for the new roles who were waiting for outcomes, extended the deadline briefly and gave him essentially a short window, a deadline by which he had to attend an interview, otherwise they were going to conclude the process. Mr. Hilaire continued to decline to attend the interview, and the council therefore decided to proceed with appointments to the new roles, and it dismissed Mr. Hilaire without having interviewed him. And Mr. Hilaire subsequently brought a claim for failure to make reasonable adjustments, saying that the requirement on him to attend the interview amounted to a provision criterion of practice that put him at a substantial disadvantage, and he argued that the reasonable adjustment the council should have made would have been simply to slot him into one of the new roles without having interviewed him. At first instance, the tribunal rejected Mr. Hilaire's claim and found, amongst its findings, that there was no disadvantage because Mr. Hilaire could have attended the interview if he wanted. Mr. Hilaire appealed to the EAT, and the EAT dismissed his appeal. It found, like the tribunal, that Mr. Hilaire could have attended the interview if he wanted. It found that the reason he didn't attend the interview was not because of his disability, but rather because he had already lost confidence in his employer and had decided that there would be no point attending the interview because he felt that his employer was going through a sham process, essentially. But what was very interesting, I think, about this case is that the EAT said that Mr. Hilaire's suggestion that he should have been given a role without an interview was wrong. What they said was that a reasonable adjustment is not a vehicle for giving an advantage to a disabled employee over and above removing the particular disadvantage. And it found that slotting Mr. Hilaire into a role without an interview would have created an advantage for him over and above those other non-disabled employees who had been interviewed. And its comment in all the circumstances was that actually there were no reasonable adjustments that the employer could have made to avoid the disadvantage that Mr. Hilaire was suffering in this circumstance. So I think quite a positive case for employers here. So obviously employers do need to consider the particular disadvantage that a disabled employee may have when complying with any PCPs, but a good reminder that employers need to balance the alleviation of a disadvantage against the creation of an unfair advantage. And so I think just a helpful case that slotting a disabled employee is not, although always dependent on the facts of the case, but not likely to be a reasonable adjustment that an employer will have to make in a redundancy situation. Thanks. And then quickly, just moving on to the next slide. As this is the last point I just wanted to make with you, and it's just about some forthcoming legislation that's likely to change probably over the course of the next year. So as you may be aware, currently under the maternity and parental leave regulations, employees who are actually on maternity leave whilst a redundancy process is underway have special protection over other employees. And essentially, if you're actually on maternity leave and put at risk of redundancy, then an employer is under a positive duty to consider if there is any other suitable alternative employment available as part of the redundancy process. And if there is, the employee on maternity leave must be given that suitable alternative employment over and above other employees. Otherwise, it can lead to an automatic unfair dismissal. Now, back in 2019, there was a consultation about whether the scope of that protection should be extended to cover those who were pregnant and for a period of time after their return from maternity leave. And essentially the mischief I think it's designed to prevent is that I think there is possibly a risk that when an employee goes off on maternity leave, an employer may suddenly think, well, actually, we seem to be managing without that employee, so let's reduce a member of staff. And I think there's a tendency to think, well, if we're managing without that particular person, we can just make that particular person redundant. So that's what it's designed to sort of prevent. And there was quite widespread support for the proposal to extend the protection. And in fact, the government committed back in 2019 to putting this legislation into the employment bill, which was set out in the Queen's speech in 2019. However, since then, there has been a delay in the employment bill coming in. I think obviously the government has had other pressing matters in between. So we're no closer as yet to having a draft employment bill to look at. And as a result, in October last year, one of the MPs put forward a private members bill to try and bring this particular piece of legislation into force. And the government have lent their support to this private members bills. Lots of private members bills get not very far, but this particular one, it looks like it's reached its second reading, and it looks like it is due to take effect, possibly I would say October of this year, but it remains to be seen. But the proposals, if it comes into force, are that the additional protection will come into force at the point at which an employee notifies their employer in writing that they are pregnant, and then will run from that point through the maternity leave and 6 months after the maternity leave ends. And it's also proposed that it should cover other types of family leave, so specifically adoption leave and shared parental leave. So yes, watch this space. And that's all I had to say on redundancies. Now I'm going to pass you back to Michael to have a look at restrictive covenants.
Thanks, Lorna. Thank you very much for that informative presentation. I want to briefly touch now on the thorny issue of post-termination restrictions contained in employment contracts. Generally speaking, where you have individuals within organisations that can cause commercial damage, it is quite common to include post-termination restrictions, restricting the activity that departing employee can undertake, particularly if they're going to join a competitor. And I've always generally advised that trying to prevent an employee from leaving one organisation and joining a competitor can in fact be difficult to enforce, particularly if there are other restrictions governing the employment, such as the departing employee not being able to contact and deal with clients and candidates, etc. But the non-compete seems to have enjoyed a bit of a resurrection or renaissance in recent years. And I want to focus on a couple of cases relating to trying to prevent employees from joining competitors. But I think the starting point before you get to that is that where you have restrictive covenants in contracts of employment, the starting point is what legitimate interests is an employer trying to protect? And in most situations, the legitimate business interests include trade connections between the employer and its clients and customers, candidates if you're a recruitment business, and you're also trying to protect obviously your confidential information, and also I think importantly to stop team moves. So those are generally what I would term the legitimate business interests that employers are trying to protect. And the next point following from that is also any protection must be no more than is reasonably necessary so as to protect those interests. And the scope of the restrictions are to prevent a departing employee from joining a competitor and not to solicit the clients and the candidates and deal with those. And also I've seen certainly over the years that the duration of those restrictions can vary from anything from 3, 6, 9, 12 months, even longer. And the issue when employers try to enforce those restrictions is whether that duration, whether it's 3, 6, 9, 12, or even more, is a reasonable period of restriction. And also, as I was saying, confidentiality is obviously key as a legitimate interest that employers are trying to protect. And also, there is a continuing obligation in any event on the part of a departing employee to keep their employer's information confidential. But I've certainly seen with recruitment agencies that they do sometimes hire individuals and they bring along candidate databases, and that can lead to all sorts of difficulties for the new employer, particularly if it is discovered that they have obtained a former employer's confidential information. Next slide, please. So just as a practical rule, what I suggest you do when you are considering restrictive covenants for individuals, firstly, look at the role of the employee. What is he or she, what are they employed to do? How much commercial damage could they cause you if they leave? What level of contact do they have with the clients, the customers, and the candidates? And also as well, draft those restrictions in accordance to the principles that I was talking about earlier. Do not, as the slide says, make mistakes about using a template contract, a one-size-fits-all situation. And I see that time and time again, where individuals are given wholly inappropriate contracts of employment with restrictions. Also, as well, bear in mind that if you have to enforce these restrictions, the courts view the restrictions at the date the contract of employment or the date that those covenants come into effect. So not at the date when someone is actually leaving an organisation. So again, you have to bear in mind that where you have a set of restrictions, if people are essentially promoted within your organisation, then you may need to review those covenants from time to time so as to make sure that they are suitable and appropriate. Next slide, please. The first case I want to look at is a recruitment case. It involved Apex Resources Limited, who supplied temps in the construction sector. And McDougall and 2 others were subject to similar restrictive covenants, which prevented them from competing with Apex in the construction sector for a period of 6 months. McDougall and 2 others joined a rival agency, and Apex sought to take out an injunction against those 3 departing employees and preventing them from joining the new employer. Next slide, please. And you'll see set out on this slide the covenant which applied to those 3 departing employees. So essentially to prevent those 3 departing employees from joining any competitor in respect of business activity which they had undertaken in the previous 12 months, which essentially meant, or in this particular case, that the 3 employees couldn't work in the construction recruitment sector for a period of 6 months, because that was activity that they had undertaken in the previous 12 months. So, next slide, please. The basis of the court's decision in upholding those 6-month restrictions were essentially summarised on the slide, that Apex managed to persuade the court that those restrictions were needed so as to essentially prevent the Apex from losing its commercial relationship with its clients and candidates. And they also needed time to replace and integrate new employees with the clients and the candidates, with whom relationships were actually in existence and in place with those three departing employees. The court, I think, was also influenced by the fact that three individuals were leaving at the same time. And Apex again managed to persuade the court that the restrictions preventing these three employees from joining a new agency which had started up in the construction sector, relatively local from where Apex carried on business, that there was a need to essentially preserve the integrity and stability of the Apex workforce. Another argument that found favour with the court as well was that the departing employees could work in other recruitment sectors outside construction. So in other words, these three employees could have joined other recruitment businesses that weren't undertaking construction. But I think one has to look at that and ask the question as to how realistic or appropriate that is, because of course, if someone has a specialist skill in a particular discipline and sector, it's not always easy and it takes time to actually develop new skills. So if someone, for example, was working in construction, how easy would it be for them to migrate, for example, to healthcare recruitment? I don't know. And the final point was that the court was persuaded that the balance of convenience favoured an injunction. So in the end, McDougall and the other two employees were essentially prevented from joining the rival competitor for a period of 6 months. Next slide, please. Law by Design and Ali is another case involving the provision of professional services and actually involved a law firm. And in this particular case, Ms. Ali, who was an employment lawyer specialising in healthcare, was subject to a 12-month non-compete covenant. And she resigned and sought to join a competitor, and again had covenants which prevented her from soliciting and dealing with the clients. And again, you'll see from that slide that she was prohibited for this 12-month period of not being involved in any capacity with any business that essentially competed with Law by Design. Law by Design essentially provided employment services to organisations particularly involved in healthcare and the NHS. And you'll see there that restrictive business was defined as those parts of the company, i.e. Law by Design, with which the employee, i.e. Ms. Ali, was involved to a material extent in the 12 months before she left Law by Design. Next slide, please. And the court upheld the 12-month non-compete, again, on the basis that Ms. Ali could work in other areas of law that were essentially not associated with healthcare. But the difficulty and the reality of the situation is that, again, she was a specialist healthcare employment lawyer, but again, the court wasn't dissuaded by that fact, and again took the view that she had certain skills that could be utilised elsewhere, essentially following part of the judgment in the Apex and McDougall case that I was just talking about. But again, I think it is questionable as to employees who do undertake specialist work, how easy can they actually change their discipline? I'm not sure that the courts are right on that. Next slide, please. So again, the factors that were considered by the court in the Ali decision is again following Apex and the time that it would take to find a replacement for Ms. Ali. And I think as well, what also influenced the court heavily, that as part of the disclosure process, Ms. Ali had drawn up the business plan for her new employer, which law by design, the former employer was able to show that there was a deliberate intention to migrate the client base over to the new employer. So I think that also weighed heavily in their decision. But as most recruiters and hirers of new staff will be aware, that in many situations where individuals are essentially hired by new organisations, they are generally asked to prepare a business plan for their new employer so as to justify their employment. And all I can say is this, that if you are considering moving jobs or you are intending to employ someone senior within your organisation, be very careful about the way or your requirements that they draw up business plans, because that essentially could be discoverable if you're on the end of legal action. Next slide, please. Dwyer seems to potentially reverse what I was just saying earlier, but there are slightly differing circumstances here. So a one-year non-compete within a franchise agreement was held to be unenforceable against Mr. Bartlett. And the facts of the case were that Bartlett had his own company called Fred Bar Limited that had entered into a standard lengthy franchising agreement with Dwyer, and within the terms of the franchise agreement, that if the franchise agreement came to an end, that essentially Bartlett would be prevented for a year from essentially undertaking marketing business within a certain territory. And that 1 year non-compete was held to be unenforceable. Next slide, please. And what had actually happened in this particular case was that the franchising agreement essentially wasn't working, that Fred Bar had got into financial difficulty and the franchise agreement was ended. Dwyer then sought to prevent Bartlett, in his capacity as an individual, from essentially carrying on business within the agreed territory. And essentially what happened was that the court refused to uphold the 1 year non-compete, preventing Bartlett from carrying on his business activities within a certain territory. And I've set out on the slide the basis of the decision. Again, it's not an employment decision, it is one where the restriction is contained within a business agreement. And I think the overriding concern was that preventing Bartlett from carrying on as a self-employed individual or joining a competitor essentially would have had an impact and loss of his livelihood. Unlike the other cases where the court seems to have taken a view that those individuals, by imposing restrictions on them, that their livelihoods weren't impacted. And again, other factors were the inequality of the bargaining position between the parties. But again, as most employers, hirers will know, that when someone actually goes for a job and the hirer or the new employer wants to impose covenants, then there is generally inequality of bargaining because the hirer or the new employer is essentially saying, accept these terms or you don't get the job. Another factor, again, in the Dwyer case was that Bartlett and Fred Bar had invested a significant amount of capital into the franchise, which essentially was going to be lost. But the courts also made the point that there was no general rule that a 12-month non-compete was reasonable. And again, in all these cases that are reported, as Lorna said, they are generally decided on their own facts. So with that, I'll hand over back to Lorna.
Thanks, Michael. Sorry, just struggling to unmute there. So thank you. And what I want to do just briefly now is draw your attention to some new e-learning courses that are offered by VWB Plus. And the first is our HR and Employment Law for Line Managers training. And this is a series of 9 short e-learning courses written both by lawyers from BWV and HR consultants from our sister company, Narrowkey HR. And they are primarily designed to upskill your line managers to enable them to deal with some common HR matters. So as you'll say, the 9 courses that are covered are set out there on the slide, and they're a mixture of sort of some reading, some short video clips, and some questions to test knowledge, which take around about half an hour each. And if you want to sign up to those e-learning courses, then the cost is £700 plus VAT per annum. And for that, each client gets their own site. You can appoint some administrators who have control over who has access to the courses and which courses they have access to. And you can track and monitor completion of the courses. And you can also upload your own organisation's policies, such as your disciplinary policy or your grievance policy, for your managers to read alongside doing the training. So I think you've got unlimited access to the courses for as many management as you choose. And so hopefully you feel that that would offer some good value, I think, as compared to paid for in-learning training. It probably does. And certainly from the feedback we've had, they're only very new, they only went live at the end of last year, but from the feedback we've had so far, I think clients are saying that they're really giving their line managers the confidence to go out and deal with some of the trickier issues, and also that they're really valuing the ability to be able to go back in and refer to the courses as and when an issue crops up and they need to do so. And then if we can move on to the next slide. We also do offer some similar e-learning on the data protection sphere, and it works in a similar way, although the costings are slightly different as set out on the slide. But given the amount of data that particularly recruitment organisations deal with, it offers a really useful way, firstly, of ensuring that your employees understand their obligations, and also of demonstrating, I think, that you have trained them on their obligations in that regard. So we're going to flick onto a new slide now, and if you are interested in finding out any more about either of those e-learning options, then please do indicate that on the voting button, and someone from VWV Plus will be in touch with you to give you more information. I think Jessica's running that, so I'm not sure when that closes down. I'll give it a minute to allow you the opportunity to vote. Perfect. So my box has disappeared, so I'm assuming that voting has completed. So we did allow a few minutes at the end now for any questions. I can't see that there's any Q&A in the chat function, but if anyone does have any questions that they'd like to ask, please do put them in there or in the chat.
I've just seen one, Lorna. Is a temp agency liable for any acts of discrimination or harassment if it supplies temps where the hirer is involved in a strike situation? I think that's quite an interesting question, and it revolves around the status of the agency worker, whether they are an employee of the temp agency or indeed whether they are a worker. So, but I think generally an agency or a temp agency really needs to be very, very careful if it does in fact supply temps in striking situations, as they could be liable potentially for acts of harassment and discrimination that might be caused as a result of a volatile situation into which the agency worker is placed. So I think the advice on that is care is required.